Welcome to the Deep Dive. Today we're tackling something really crucial if you're renting a place in California.
That's right. We're talking about the Tenant Protection Act, also known as AB 1482.
It's a pretty big deal, isn't it? Changed a lot for renters.
Absolutely, a game changer. And, it can be complex, so we wanted to really break down what it means for you, the tenant.
Yeah, we've gone through the details, the official sources, all that, to try and give you a clear picture, focus on the key protections.
Exactly. So our mission today really is to arm you with the essential knowledge about your rights, especially when it comes to how much your rent can go up and the rules around eviction.
Okay, and we'll cover the statewide rent cap, these just cause eviction rules.
Yeah.
What else?
We'll definitely get into the exemptions, which properties aren't covered. That's super important. And also how this state law, fits in with any local city or county rules.
Right, because sometimes local rules are even stronger.
Precisely. And we'll touch on what happens if, a landlord doesn't follow these rules.
And just quickly, before we jump in, we should mention Martinez Law Center. They specialize in helping tenants with eviction and unlawful detainer cases.
Yeah, specifically tenants. That's their focus. They cover Orange County, Riverside, San Diego, and Los Angeles County.
Good to know. Their website is martinezlawcenter.com if you need that kind of help. Again, that's martinezlawcenter.com, representing tenants.
Okay, great resource to keep in mind.
Definitely. So let's start with the big one, money, the rent cap. What's the basic idea there?
Okay, so the core principle is this. Your annual rent increase is generally capped. It's limited to 5%, plus the change in the local consumer price index, the CPI.
CPI, that's like inflation, right?
Exactly. It reflects the cost of living changes. So 5% plus that CPI figure, but there's another ceiling. Yeah, the total increase can never be more than 10% in any 12-month period. So it's whichever is lower, 5% plus CPI or 10%.
Okay, that makes sense. It puts a clear limit on things.
It does. It tries to give tenants some predictability while, allowing landlords some adjustment for economic changes.
So can you give us some actual numbers? Like, how does this play out in different areas? Because CPI varies, right?
It does vary by region. So looking at the recent period, say August 2023 through July 2025, let's see. For the LA area, that's LA and Orange counties, the max increase allowed was 8.8% for the first year of that period, and then 8.9% for the second.
Okay, under the 10% cap.
Right. Now, Riverside area, so Riverside and San Bernardino counties, it was a bit higher, 9.6% than 9.3%.
Still under 10%?
Yep. San Diego County actually hit the 10% max cap in that first year, August 23 to July 24. Then it dropped to 8.6% for the following year.
Interesting. And the rest of the state? Like the Bay Area?
Yeah, San Francisco Bay Area counties and basically all other counties in California, they had caps of 9.2% and then 8.8% for those two periods.
So it really does depend where you live.
It absolutely does. And this is crucial. Some cities have their own even stricter rules.
Right. You mentioned that earlier, like where?
Well, places like Antioch, Oakland, Santa Monica, they have a 3% cap, even lower.
Wow, okay.
And Pomona, Bell Gardens, they're at 4%. So you really, really need to check your local city or county rules too. AB 1482 is just the minimum standard for the state.
Good point. Always check local first. Now, about these increases, it's not just the percentage. The landlord has to tell you properly, right? Give notice.
Absolutely. Proper written notice is required. If the rent increase is 10% or less, they had to give you at least 30 days written notice.
Okay.
But if it's more than 10%, which under the current statewide cap isn't really happening much, but if local rules allowed it or exemptions applied, then you'd need 90 days notice.
Got it. 30 days for up to 10%, 90 for over. Makes sense.
And one other thing here is vacancy decontrol.
Vacancy decontrol, what's that?
It means when a unit becomes vacant and the landlord rents it to a new tenant, they can set that initial rent at whatever the market will bear. There's no cap on that first rent amount for the new person.
Ah, okay. But once that new tenant is in,
then any future rent increases for that tenant are subject to the AB 1482 caps we just discussed.
Okay, that clarifies things. So rent caps covered. Let's shift to the other big protection. Evictions. The law talks about just cause. What does that actually mean for a tenant?
It's a huge protection. Basically, once you've lawfully lived in a rental unit for 12 months, your landlord can't just evict you for no reason or, just because they feel like it.
So they need a specific, valid reason.
Exactly. They need a just cause that's recognized under the law. It adds a significant layer of housing security, especially for longer-term renters.
And I think you mentioned there are like two types of these reasons.
That's right. The law splits them into at-fault reasons and no-fault reasons.
Okay, let's start with at fault. What kind of things fall under that? Sounds like things the tenant did wrong.
Pretty much. It's based on the tenant's actions or maybe inaction. The most obvious one is failure to pay rent.
Makes sense.
Other examples would be breaching a major part of the lease agreement, like, say, having a pet when the lease forbids it. Though, importantly, for many breaches like that, the landlord usually has to give you written notice first and a chance to fix the problem, often 3 days. It's called a right to cure.
Okay, a chance to fix it. What else is at fault?
Causing significant damage to the property beyond normal wear and tear, obviously. Using the property for illegal activities. Refusing to let the landlord enter the property when they have a legal right to, like for repairs, with proper notice. Also engaging in criminal activity on the premises or criminal threats against the owner or manager. Refusing to sign a new lease with similar terms after your old one expires. Subletting the place unlawfully. Things like that.
So a list of serious issues related to the tenancy itself.
Correct. Actions that violate the agreement or the law.
Okay, then what about the no-fault reasons? These aren't things the tenant did wrong.
Exactly. These stem from the landlord side, usually. There are reasons for eviction that have nothing to do with the tenant's behavior.
Like what?
A common one is if the owner or their close family spouse, kids, parents, grandparents, wants to move into the unit themselves.
Okay, but I bet there are rules around that. They can't just say that, right?
There are definitely rules. They have to intend in good faith for that person to live there as their primary residence for at least a year. And they usually have to move in within 90 days of the tenant leaving. Plus, the landlord has to tell the tenant in the eviction notice who's moving in. And this is important. It usually only applies if the landlord doesn't have another similar vacant unit available.
Lots of conditions there. What other no-fault reasons?
Another is if the landlord decides to take the property off the rental market entirely. Just stop renting it out.
Permanently.
Or for a significant period, yes. Also, if they need to comply with the government order to vacate because the place is uninhabitable, maybe after a fire or something.
Yeah, okay.
And the last main one is if the landlord plans to demolish the property or do a substantial remodel.
Substantial remodel. What counts as substantial? Like new paint?
No, not just cosmetic stuff like paint or new carpet. It has to be significant work that requires permits. And it genuinely requires the tenant to move out for safety reasons.
Yeah.
Usually for at least 30 consecutive days.
Okay, so major construction work.
Right. Not just a quick facelift.
Now, if a tenant gets evicted for one of these no-fault reasons, owner, move in, remodel, etc., they're basically being asked to leave through no fault of their own. Do they get any help?
Yes, they do. For no-fault evictions under AB 1482, the landlord is generally required to provide relocation assistance.
How much?
It's typically equal to 1 month of the tenant's rent at the time the notice was issued. The landlord can choose to either pay that amount directly to the tenant within 15 days of the notice, or they can waive the final month's rent.
So either cash or free last month?
Essentially, yes. And there's another protection here, too.
Oh.
What if the landlord says they're moving family in or doing a remodel, but then they don't?
Yeah, what happens then?
Well, if the owner or relative doesn't move in and occupy the unit for the required time, or if that substantial remodel doesn't actually happen or the unit is rented out again too soon, the original tenant might have rights. They could potentially sue and might even have the right to move back in under the same rent and lease terms. Plus, they could possibly get reimbursed for moving expenses that exceeded the relocation payment.
Wow. Okay, so there are consequences for landlords not following through on the stated reason.
Definitely. It's meant to prevent misuse of the no-fault grounds.
This is all great info, but you mentioned exemptions earlier. Not all rentals are covered by these rent caps and just cause rules, right?
That's a critical point. Yes, there are quite a few exemptions. Probably the biggest one is newer construction.
How new?
Buildings that receive their certificate of occupancy within the last 15 years are generally exempt. And that's a rolling date. So a building built 16 years ago might become covered next year.
Okay, so brand new buildings are often exempt for a while. What else?
Single-family homes and condominiums are often exempt too, BUT. Big caveat here. They are not exempt if they're owned by a corporation, a real estate investment trust, a REIT, or an LLC where one member is a corporation. Also, for this exemption to apply to individually owned single-family homes condos, the landlord must have given the tenant written notice, stating that the property is exempt from the rent cap and just cause rules.
So, if you're renting a house from an individual, you need to check your lease or notices to see if they claimed that exemption.
Exactly. If they didn't provide that specific written notice, the property might still be covered, even if it's a single-family home.
Good to know. Any other major exemptions?
Yes. Duplexes, where the owner lives in one of the units as their main residence and has since the beginning of the tenancy, those are typically exempt.
Owner-occupied duplexes.
Right. Also, most forms of affordable housing that have deed restrictions or are subsidized, dormitories owned by schools, rooms where the tenant shares a bathroom or kitchen facility with the owner who lives there, hotels and other transient housing meant for stays less than 30 days, housing provided by nonprofit hospitals, religious facilities, extended care facilities. Those are generally outside the scope of AB 1482 as well.
So quite a list. It really emphasizes the need for renters to figure out if their specific situation is covered or exempt.
Absolutely. You can't just assume you're covered.
Now, how does this state law interact with local laws? We touched on this, but if a city has its own rent control?
Good question. AB 1482 sets the floor, not the ceiling, for tenant protections. So if a local ordinance, say, in Los Angeles, San Francisco, Oakland provides greater protection than the state law, like a lower rent cap or stricter eviction rules, then the local law prevails in that area.
The stronger protection wins.
Exactly. But if a local law is weaker, or if there's no local law covering a specific issue, like, say, just cause eviction, then AB 1482 fills that gap and provides the statewide minimum protection.
So it works together, aiming for at least the state level of protection everywhere, potentially more locally.
That's the idea.
Okay, so what happens if a landlord violates these rules? If they raise the rent too much or evict without just cause, what can a tenant do?
Tenants have legal recourse. They can file a lawsuit against the landlord.
To achieve what?
They can seek to recover actual damages, basically, any money they lost because of the landlord's illegal action. For example, the difference in rent paid, moving costs if wrongfully evicted, things like that. And significantly, the law allows tenants to potentially recover their attorney's fees if they win.
That's important, makes it more feasible to fight back.
It is. And there's more. If a court finds that the landlord acted willfully, meaning intentionally violating the law or with oppression, fraud, or malice, the landlord could be ordered to pay punitive damages, potentially up to 3 times the amount of the tenant's actual damages, treble damages.
Wow, serious penalties for bad faith actions.
Yes, and it's not just tenant lawsuits. State or local government agencies can also investigate and take enforcement actions against landlords who violate the Tenant Protection Act.
So, real teeth in this law. And if a tenant is facing eviction, maybe unfairly, or feels their rights under AB 1482 are being violated, where should they turn?
Well, seeking legal advice is always recommended in complex situations. And as we mentioned earlier, for tenants specifically facing eviction or unlawful detainer actions in Orange County, Riverside, San Diego, or Los Angeles County, the Martinez Law Center specializes in representing tenants in those situations.
Right, martinezlawcenter.com. They focus only on the tenant side for evictions.
Correct. That's their specialization in those counties. It's crucial to get help if you think your landlord isn't following the law.
Absolutely. Knowledge is power here. So, wrapping this up, what's the main thing listeners should take away from our deep dive today?
I think the biggest takeaway is that AB 1482, the Tenant Protection Act, provides really significant rights for many, many California renters regarding rent increases and eviction stability. It's not universal due to the exemptions, but it covers a lot of people.
But you have to know the details.
You absolutely have to understand the specifics, the caps, the just cause requirements, whether your unit is exempt, and how your local city or county rules might add even more protection. Knowing your rights is truly the first and most critical step.
Couldn't agree more. And remember, this conversation has been a general overview. Your specific rental situation might have unique factors.
Definitely. If you're facing a specific problem or have detailed questions about your lease or a notice you received, getting advice from a legal professional or a tenant rights organization is always the best course.
Sound advice. And again, for tenants needing help with eviction defense in Southern California, Orange County, Riverside, San Diego, Los Angeles, check out martinezlawcenter.com.
It's been great breaking this down. Hopefully it helps renters feel more informed and empowered.
Me too. Thanks for joining us on The Deep Dive.
Call now 714-442-9741. Thank you.